Okay, so let us start with the class. Will be around 1.5 hours, right? And here I will explain you, distinctly four different things. Okay, the first thing that I will be explaining you that what type of question that actually comes in the test series. I mean, in the normal optional paper, right? And how to approach those questions. Okay, so we'll make a sort of a generalized guideline, right? That what can be done in these questions, right? If the questions is of similar type, right? Similarly, we will talk about these three things that I keep telling you, right? That in every class, that as a law student you should always focus your answer something like this. Okay, it means you should focus on your content, structure, and preparation. Also, I will be showing you some of the copies, right, where I will show you that okay, this is what when I was talking about, this is what it is about, structure. This is what I am talking about, presentation. Okay, so I will be showing you different copies also, right? So to give you an idea, right, that how to write the answers. Okay, so that is the second point that you must remember. Similarly, the third thing that I will be talking about is which part of the syllabus you can focus more, right? Now, when I say that which part of the syllabus you should focus more, that doesn't mean at all that the other part of syllabus you need not to focus. It is simply a guideline that okay, these are the something which you can, study more and give more preference. Right? That doesn't mean that the other part you don't have to study, not at all. Right? So that is the one thing that I must keep in mind, right? And then what is the routine of the test, right? And how will it utilize it? Okay, so what a strategy you can actually follow, right? So that particular thing I will be talking about. Okay. Now, let me a little bit tell about one more thing is that the whole structure of the syllabus have been divided into total 10 tests, right? All of them is the full length test, right? So the first 8 tests will be sectional, right? So I have planned the syllabus in that manner that we have, two paper, right? Paper 1 and paper 2. Now in paper 1, we have 2 sections, right? Section A, section B. Section A, section B. In paper 2 also I have 2 sections, that is your section A, section B. Right? Very simple, right? So from each section we have 2 full length tests. Okay, right? So it means from constitutional and administrative law, you will have 2 full length tests. From international law, you will have 2 full length tests. From section A, that is your crime and tort, you will have 2 full length tests, right? So 1 full length test for crime, 1 full length test for tort, right? And then finally, in the case of CLD, you will have 1 full length test, and commercial law, you will have 1 full length test, right? So that will be 8 full length tests, right? From each section, there will be 2, right? And 2 full length tests where the syllabus will be 8 total, right? So let me actually show you itself. So this is the routine actually, right? Test number, right? So that means the test 1 to 8 are basically sectional but full length. Okay, so there will be properly 8 questions. Each question will contain similar structure that we have in UPSC. Okay, very proper full length test. Okay, then you will have these 2, test number 9 and test number 10. The syllabus will be full length. Okay, so paper 1 whole syllabus test number 9, paper 2 whole syllabus test number 10. Okay, so that will be the 2 full length. Okay, so altogether there will be 10 full length tests. Okay, now I have given you the syllabus itself, right? See here that paper 1 section A from constitutional and administrative we have 2 tests, right? So that I have already told you that in section A, paper 1 2 tests, section B paper 1 2 tests, right? Similarly, 4 tests in section in paper 2, total 8 tests and 2 full length. Okay, it means the purpose of the whole syllabus should be covered in a very good manner. Now, if you will see, altogether we have around 70 topics, right? 72 to be precise, right? Now, in each 72 topics, right, I have given, suppose 8 tests, right? So we'll have around 8 to 9 topic in each test, right? And I have given you the time of 1 week, right? So what I will suggest you to do is that you take 1 topic each day, see the previous year paper, and read whatever you have already read or anything that you need to add on that. Okay, identify good quality, lines that you need to write in that particular paper. Understand that particular point, right? So the each week you have around 7 to 8, not more than that. Always, 7 to 8 topics, not more than that, right? So each week you have 7 to 8 topics, right? And end of the week you will see that each Saturday actually I have planned the test. See, if you see the routine, it is mostly each Saturday. Okay, so each Saturday I have planned the test. Okay, so you read for the whole week, write it, submit it to me. I will evaluate it in the next 1 week. Okay, and then go for the next week. Understand that particular point, right? Now, one thing that I will ask you that first test I will discuss 1 to n like this. Right? So once you will give me the first test, I will discuss it one to one, right? Why I will discuss one to one? So that when I will check in front of you, I will actually pinpoint it that okay, this is the one that you have not written nicely. This is the one where you need improvement. Okay, so that will actually give you help you that whenever I will write certain remarks afterward, right? Then you will be able to understand that okay, this is what I'm trying to convey, right? Like for example, I will show you some copy actually. Like see this copy. Suppose Sterling here say I've written a copy, right? So suppose I'm checking this copy, I've written here heading, right? So what does it mean? I want you to write heading here. Okay. Similarly, I have given certain comments like you can explain diagram. You can use diagram to explain this concept, right? So when I will be writing these things, right? So first, when in one-to-one discussion, I will explain you that what I'm trying to write. Okay. I mean what I'm trying to convey. Then you will be able to understand my next copy that I will give you feedback. Okay. So one test I will check one-to-one. Understand that particular part. After that, I will not check copy one-to-one. I will simply check it. You will be sent PDF. You just read by yourself, right? But I will take discussions, generic discussions. See, so test 1, 16th October, you will write it. So when you will have test 2, right? The same day I will have discussion. And discussion will be same timing, that is your 6 to 8. Understand that particular part, right? So you will get the copy in the morning, right? You get a printout of the pages, right? Around 30 pages. Sit in a room, right? Take 3-hour time. That is very important, right? Take properly 3-hour time, okay? And then lock the room, and then start studying. Okay, so that one thing, please keep in mind. Don't cheat yourself. Okay, ultimately, no one else you are cheating it. Right? It is ultimately you that you have to give the test. Okay, understand that particular point. Okay, and you will send me the the PDF, or you will send to the de facto people. Anyone you can send, right? And I will evaluate and give feedback on that. Okay, so that is how the whole structure will function. The structure of the course is clear. Yes, everyone. Right, so you have to type yes so that I will understand. There is a chat box open. You will type yes. I will understand that yes, you have understood what I'm trying to say. Yes, everyone. Sandhu, Mr. Animesh, yeah, okay, good. So that is the first part, right? And I have written that part itself here, right? That is the same thing, right? Designed for 10 weeks, right? But it can be extended up to 6 months. But I will ask you not to exercise this particular clause, right? To try to finish it in the 10 weeks, okay? So that you will have around 15 days time before writing this. Now, even if some of you do not get into prelims, right? Then also that's all right. You write the test, okay? Do not get disheartened. Write the test. I mean, most of you will get into prelims, no doubt, right? And let me tell you a secret, right? Last year, the 3 guys that qualified, right, were my students. 2 of them was test series students, actually, right? So test series students are more prone to qualify rather than non-test series students. Yeah, these are the things, okay? And this I have specifically given. Do not procrastinate, okay? That is not a very good attitude, okay? Do it then and there. Similarly, you can suppose there is some specific queries, right? One test I have told you I will do one by one, right? Suppose in the next test you have some specific queries, right? You ask me, message me I need some time, right? So I will alert you a particular time, and then we will have this Zoom one-to-one talk. Okay, not always, few topics. If you have any doubt, I will explain that. Okay, that is no problem. Now, one more thing I wanted to say that I will write I write an article in which I take all the major cases of that particular year, right? And I give you a sort of a 3-4 lines about that particular case, or good lines about that particular case, right? So that you can use that particular case line directly in your exam, right? Like last year I have done it, right? And very beautifully 2 questions actually came from that particular article itself. What I have done actually, I went to the live law, right? And in that live law, all the you also must be having subscription, right? So I have taken all the major cases that they have described, right? That they had thought is important. Similarly, bar bench I have, and there is one more very interesting website, SC Observer, Supreme Court Observer, right? So I have taken that 3-4 websites, right? And from that I recognize that okay, these are the cases which is relevant for our optional syllabus, right? And I take make a gist of it, right? And that gist I finally give in a form of article, hardly 10-12 pages, right? And that will immensely help you. And last year, as I have told you, almost 3 questions directly came from this. Okay, so that I will do, right? So please keep that in mind. That is very important. But that I will provide you in the last of the class. Okay, once everything is over, right? When you are going to give exam, just before going to 1-2 weeks before I will give you that. Okay, so remember that particular part. Okay. Now, one thing, I will actually show you here. Give me a minute. I'm sharing another here. You see this? Can you all see this article? Yes? Yeah. Okay. Now, when you see this article, you can see, it was published on 29, right? And I have given, see here, Sabrimala judgment, right? So what I do actually, that I pick out, beautiful cases and lines from it. Like, see this line, women is not lesser inferior to men, right? These are something you can directly verbatim quote in exam, and that will make your answer very good. Okay. Similarly, Navtej Singh Johar, it came in exam, right? Similarly, we had, and I have given, justice this, I've given written this, justice this, I've written this, right? So this the purpose is, that you should have certain ready-made, hand-made paragraph that you can practically verbatim quote in your exam. Okay. Similarly, and this will be relevant for this year also, right? Similarly, Justice Puttathwamy judgment, Joseph Sain, that also came into, right? In the exam that also came. Right. Similarly, this common cause, right to die, fundamental right, right. So that is a very important case again, right. Similarly, this case regarding qualification, however, this has been referred to the larger bench. So let us see. Similarly, this Manav Adhikar, right, 498A, crime against women, we have that syllabus. Similarly, this, Safin Jaha versus Sokam, right to change your religion, it was also a very important case, right. Similarly, the last, government of NCP plus Delhi, that was also, that came in exam, right. Important lines from judgment, as you can see, right? And finally, Lok Prayari. This is the case in which I am also related to. Okay, Lok Prayari is an NGO in which I am related to, right? So that again case was an important case. No question was there, but still it is an important case, right? UP Chief Minister, you must have seen, they have vacated their houses. Understand that particular part, right? So something similar I will prepare for you. Okay, something similar I will prepare for you, right? And that will help you obviously, writing your exam. Understand that particular point? Yes, everyone. Clear? I mean, are you able to see this particular paragraph? Yes? Okay. Check. So similar thing I will prepare, right? That I will prepare just 2 weeks before exam, right? So that, you will be able to understand it. Check. Now, so this is, about the structure, right? Now let us come to the second part of the discussion that we will be having today, right? And that second part of discussion actually relates to that how to approach different type of question that will come in exam. That is the second part of the question, and that is actually very important. Now, if you look at the whole, structure, then primarily speaking, I find that there are 4 type of question that comes in exam. Right? 4, primarily speaking. Now, these 4 type of question, what happens that when you try to answer these questions, you get confused at what to write. Okay, I mean, your brain don't work that, okay, what to write in first, what to write in beginning, what to write in the body part, right? So what I have done here, that I have identified those 4 generic type of questions, right? And what should be the model approach and structure for those generic type of questions, right? So once, you identify the type of question that, okay, it falls in type 1, type 2, type 3, or type 4, whatever, right? Then you should be by default able to write that down in the exam that, okay, this is a type 1 question, and these are the elements that must be there in this type of question. In answer, these elements must be contained in that particular answer. Understand that particular part. Okay, right? Now, what are those 4 type of questions, right? So basically, those 4 type of questions are, let me have write it first. One is the direct type. Second is the direct plus direct, right? So direct type is simply explanation of syllabus. Then we give you a topic. Full stop, comment. And most of this direct type question comes in international law, right? State-sponsored terrorism, write a short note on. Yeah, write a short note on, innocent passage. Okay, or culpable homicide is murder, or murder is not culpable homicide, right? That's one is a species, another is, so that type of question. Okay. Now, if you look at that type of question, right, when you are talking about that type of question, right, then the second type of question comes, that is with direct plus direct. They take 2 topics and club. Murder topic might be, crime against women topic might be clubbed with crime against human body. Okay. Similarly, negligence topic might be connected with damages topic. Right? So it means they take 2 topics of the same syllabus, of the same subject, and they connect it. Right? So that is your direct plus direct. I will give you the examples also. I will say so I will show you the questions as well, right? So that you will be able to identify. Third type of question that comes is basically direct and plus philosophical. right? That is the question is that, they write a very beautiful line, right? This is a very beautiful line. And full stop. In light of the above statement, discuss this concept. Okay. Simple, right? It means there is a philosophical part here, right? And there is a direct question involved. That, okay, this is the question that you have to answer, right? So there is a concept and a philosophical aspect of that concept. Okay. So in that question, the exact answer will be you have to explain this concept, and the conclusion will be that philosophical part. Understand? I will show you. I have given an example of the question also. I'm not sure you will understand. And the fourth type of the question, which is the most tricky one, right? And the student find it very hard to write that question, is basically pure philosophical. A very good line, right? Discuss its relevance. What do you think about it? Suggest some improvement. Okay, very philosophical, very generic answer. I mean, very generic questions, right? So it means those are the questions which can be exactly replaced in GS paper 2 as well, and it will make no difference, right? But obviously there has to be a difference when you are writing a GS2 paper and when you are writing a law paper, right? So what will be that difference that we will be talking about? Understand that particular point, right? So there are four primary type of questions, right? So whenever you look at the answer, question, sorry, you first identify the which type of question it is. Now, there might be some, a unique question which might not fall into this category. That is all right, right? But try to understand that which category it is most closest to. Okay, which category it is most closest to, right? Now, this is obviously it is not a mathematical formula that I'm talking about, right? So it is incapable of defining precisely, right? But at least you should be, able to identify that what we are actually talking about. Very simple things. Understand that particular point. Okay, quite simple that is. Yes, I will keep asking yes that whether you all are hearing me nice and fine or not. Yes? Okay. Okay. Now, let us start with one by one. Okay. First, let us talk about direct type of question. Okay. What is direct type of question? A simple concept explained, right? So I have taken some of the questions from 2018 and 19 paper to give you a identification. See, explain the following doctrine of innocent persons. See, very simple direct question. The resolution of partnership is a resolution of partnership form, not the resolution of partnership form. Not a resolution of is a resolution of partnership form, not a resolution of partnership. Okay, in a partnership act, when you dissolve a partnership, right? So it is only form that is dissolved. Actual partnership is not dissolved until and unless all the rights and obligations cease to exist. Okay, right? So that is the concept that relates to that when the relationship between partner actually comes to an end. Okay, so very specific concept-based question, direct question. Similarly, principle of unjust enrichment finds its place indirectly under the law of contract. Okay, right? Now, if you look at unjust enrichment principle, right? That is specifically is there that okay, equity and good conscience dictates that a person should not be allowed to take benefit of his own wrong, or he should not allowed to take enrich himself at the expense of others. Understand? Very specific question. Okay, this is the section, this is the answer, right? With the case law. Similarly, assertment of the jurisdiction is a big challenge under the cyber law. Right? So it is a question related to jurisdiction under the ITR. Clear question. Okay. Similarly, explain the maxim volenti non fit injuria. Right? Knowledge of a event or a knowledge of an injury and knowledge of the risk of an injury is both are two separate things. Right? So again, a very, very direct question. Right? Now, the question is that how to approach it. Very to the pointed question, right? So the approach will be, now this is again a very generic approach that I'm trying to tell you. First is that, in introduction, you explain it. How will you explain it? That particular topic. So either you can give, if it is international law question, then you give the convention definition. Or if it is a statutory question, right, they want to know you know a particular definition of a particular crime, write down a statutory definition. Or if it is a question with regard to where no precise definition is given either in the statute or in a convention, right, international convention, right, then give a judicial opinion. Right? It means you try to explain that particular concept, right, very generically by giving these three things. Okay. Now, if if it is international law question, right, then you can actually include one and two line the history of it, right, how it evolved. Okay. Now remember, these type of questions mostly are asked in 10 marks, right? So all the questions that I have given here, mostly it is of 10 marks. Okay, right? So it means this whole introduction part you have to cover in maximum 5 to 6 lines, because maximum 15 to 20 lines you have to write, not more than that. 25 lines is the max that you have to write. Understand, right? Then you will come to the body part in which you will go into the detail of that particular concept. There you will write if there is any Latin provision. If there is a legal provision, then you will write the whole section which provides for that. Okay. If you remember, if you do not remember the whole section, merely writing that, okay, I mean, substantially writing about that, that will be also okay, right? You need not to, exactly pinpoint each and every word, right? Similarly, you go about writing its different perspectives. Right? It means, you can talk about, suppose there is any concept, right? Like, let us take an example, actually, you will understand it better. Like, suppose this, principle of unjust enrichment, right? So we'll write about that. It is based on the common law doctrine, okay? And it is based on equity and good conscience, right? And in any trade or any economy to function, right, a person cannot be allowed to take benefit, right? And that particular doctrine became part of not only contract law but also the special contract laws, right? And then you can cite provisions also, right? Like for example, in the case of suppose holder in due course, in the case of negotiable instrument, right? They also cannot unjustly benefit. Okay, they have to pass the benefit if they have got the benefit. Okay, similarly, you can cite the same thing in the case of the Partnership Act also, right? That if you go right and do a business in which you have entered already into a partnership, then you have to account for the profit to your partners. So that is again one of the specific example of principle of unjust enrichment. Am I making some sense? Yes, everyone? No? Am I making some sense? The reason I'm asking, right, again and again, that I should be able to convey that what I'm trying to say. Yes, good. Then in the conclusion part, right, you will. Sorry, in the body part again, one more thing you can do, that you can use the case law to explain that concept. Okay, that will be in fact a very good thing to do. Now, sometimes it also might happen that you don't remember the case law, use illustration. That's all right. Okay. Now, these all has to be covered in, 10 to 12 lines, not more than that. Okay, in fact, 10 lines will be much more. And then in the last, you give solution. Okay, what do you think about that, right? If the question demands it, there might be a question where suggestion is not needed, to simply skip the last point, not needed at all. And just finish in first and second one, right? Like in the case of doctrine of, suppose the doctrine of innocent passes, how we can write it? Write the evolution that, your open sea is the most lawless region, right? And there is no fixed boundary, and the boundary is very fluid, right? Then this innocent passage dictates, solves the problem that the two countries, will not come under any jurisdictional dispute. Okay, it means it sort of aids international movement of ships. Okay, in philosophical type, generally introducing it. Then write the definition, right? So a statutory definition, writing from the Vienna Convention of Law of Sea. Vienna Convention of Law of Treaty, right? So you can write, all the Law of Sea and clause articles, the related articles of that, right? Then in the middle point, you talk about its importance, right? Citing some case laws. That is, very nice. In the last point, you can write that yes, this doctrine of innocent passage, although very good, need to be governed like it can be misused sometimes. Okay, give some suggestions. Understand that particular point, right? On the last point, if you want to skip, you can skip it also. That's all right. Understand that particular point. Okay, quite simple. Yes, good. Now let us come to type 2 question. That is your direct plus direct. Okay, you will find that there is two concept that is related to each other. Let me see the example. See here, the discharge of a contract includes breach of contract, but breach of contract does not necessarily include discharge of contract. The two concepts it is connecting: breach of contract and discharge of contract. Now, if you have studied the law, contract law, you must have seen there are multiple ways that a discharge of contract may occur. Okay, completion of it, innovation, you're replacing with other contract, multiple ways, and one of them is the breach. So breach is one of method of discharge. So that is what the question is saying, right? The discharge of the contract includes breach of contract. So discharge includes breach, right? So breach automatically does not necessarily include discharge. Understand that point? Okay, right? Okay, so there is a condition about it, right? So it means there is two concepts. So how do you handle this type of question? Or let us see second question. Extradition begins where asylum ends. Two concepts: extradition and asylum. Specific topic connectivity. What is the difference between international humanitarian law and human rights law? Each year this question is there. After each 1 year this question is repeated, right? I also have given this last year paper. Also I gave this question, and this year paper also I have given this question, because these are the questions which are generally asked. Almost after each 1 year, 2 year, you will find a question of that. Understand that particular point? Okay, understand? In fact, I keep telling you, right? I mean, multiple classes, I keep telling you that, see, law often is the only paper where, more than 40-50% question is repeated, right? That is why, when you will give this test series, you will find that there are certain questions that I have already asked in previous test series also, right? The same question I have asked, right? Because, I cannot give you something, unique, which I know that is not going to come, right? So you do not mind that, you just write the answer. That is the point. Ultimate aim is to practice it. Right? You do not say that, okay, this has also been asked and last year you are giving it again. Yes, I am giving it again because I know that same question will come again. Right? That is the whole nature of this course, right? I mean, the law optional syllabus, right? The question comes, right? Especially in international, it gets repeated. It always gets repeated. Similarly, administrative power or action are not always conflict with the rule of law. So rule of law is a distinct concept and the administrative law is a distinct concept, right? So it talks about, you have to explain the interlink between two. Okay, right? So that is what I am telling you, direct plus direct. Okay, two concepts together, right? You have to identify that, okay, this comes at least close to type 2 question. Yeah, at least close to type 1 question. Understand? See, I am here talking about a very practical way of studying. Okay. Ultimately, the aim is to achieve 300 marks. Understand? Okay. We are not here to do PhD. Just remember that. We have to bloody get that 300 marks and done and dusted. Do not try to overemphasize it. Okay. Right? Plain answers, good answers. Right. We will talk about also structure content. We will understand. Now, how to approach it? Right. So, I've given here 4 guidelines. First, what you do, that the same thing that you have done in the beginning, that is a direct question, explain both of topics differently. Right. So now out of suppose 7 to 10 lines, 5 to 6 lines you give to first topic, 5 to 6 lines you give to second topic. Right, generally, write a statutory definition, or you need, jurist opinion, whatever. Just a very simple. Then in the body part, explain the connection between two, and specifically use the case law to come up with that connection. Right? Like in the case of this frustration of contract and breach of contract, right? Case law, multiple case laws are there, right? That we clearly bring out that yes, this is what actually it is talking about, right? Then, if the concept of the case law is absent, then you can sort of talk about evolution of that concept. That how this concept was initially same, later it evolved. It happens actually, right? Like for example, if you see, let us take any example. Suppose if you talk about this international humanitarian law and international human rights law, so you must be knowing that the international humanitarian law is of ancient origin, right? Later on, it was, after the coming of the UN, it was felt that no, group right might not be more relevant rather than individual rights would be there, right? So some of them was actually carved out as an international human rights law. Understand that particular part, okay, right? So that is what actually here I have written, that you may connect the concept by talking about evolution. Most often, one is subset of other. Okay, then you can write that why it was needed to bifurcate these concepts differently. Understand that particular point. Similarly, suppose this rule of law and administrative power. So rule of law dictates that the law should rule, okay, or doctrine of separation of powers should be there, right? But administrative law is needed because we do not have exact doctrine of separation of power, right? Understand that particular point, right? So the administrative law evolved because the rule of law could not be guaranteed. Understand that particular point, okay, right? So it means most often you will find if there is a question collecting two concepts, right? That is always a subset of other. Right? To explain the rationale behind it. Now that requires obviously a bit of knowledge from your side to understand the concept behind it. Okay, then in the conclusion, same thing you do, write some suggestion if you want. Okay, or if you want, you can explain it that okay, these are the recent trends that have been followed, and if that topic relates to law commission, it has been a subject to the law commission report, right? Then you can cite law commission report for that. Okay, understand? Like in the case of this, after this, gang rape, Delhi gang rape case, right? You must have seen there was a law commission report with regard to amending the provision related to crime against women, right? So those recommendations you can write. Like if there is a question with regard to contempt of court and trial by media, there is a law commission report, right, that have given certain suggestions, so that suggestions can be written. Understand that particular point. Okay. Now again, it is not a rigid framework. Suppose you forgot to write that in the end, right? You have written the same thing in the beginning. That's no problem. That is also right. Not a problem, right? But try to structure it in such a manner that each and every component that we are talking about must be there in the answer. Right? It must be there in the answer. Okay. Understand that particular point. Am I making some sense? Yes. Everyone. Again, I will want a yes from you all so that I will understand that yes, you are getting my point here. Yes? Okay. Now, let us come to the next concept. The next type of question actually is that direct plus jurisprudence, right, or philosophical. It means they give you a good line and a concept, right? And with regard to this good line, comment on this, right? Let us see example. Examining the concept of social justice and envisaged in the Constitution, more particularly in Chapter 4 of the Constitution and Article 40. So these two are the concept, and this is the philosophical part. Right? So you have to analyze Chapter 4 and Article 14 in such a way that you reach this conclusion. Right? You reach this conclusion. Right? Similarly, see question number 2. Do you agree with the statement globalization is the necessary evil? Critically examining the implication of the reform process undertaken by IMF and IBRD by the way of a structural adjustment program. So that is the concept, recent development, and use that particular concept to justify this. Is it necessary? Okay, understand? Similarly, I mean, lot of questions like that will come. Like you see this right of private defense to the extent causing death of an assailant cannot be based on the surmises and speculation. Right, so it is talking about the right of private defense must be controlled, right? It must be regulated. Okay, philosophical part. The accused must be under bona fide fear of death or grievous hurt would otherwise be the consequence of the assault. If it does not defend, to determine the existence of the apprehension is always a question of fact, right? So the actual question is that you have to answer is that in order to you to be eligible to exercise the right of private defense is a question of fact, right? Whether the condition is satisfied given in IPC is there or not is a question of fact. And what are those conditions? You written here also, right? You must be in a bona fide fear of your death or grievous hurt. So that is a direct question, right? But the philosophical part is that these things has to be decided in a manner so that you should not be able to, you should not be able to base your exercise on some speculation or surmise, right? You might think that I might be dead. So that is not it. Right? So the philosophical part of it is that, right of private defense should be exercised very, very cautiously. Right? So whenever a right of private defense is, alleged by the criminal, right? Taken as a defense by the criminal, alleged criminal, not exactly criminal, right? Then the court should take into account that it must be guarded cautiously. That is the philosophical part. Understand that particular point. Okay, so there is one concept and the philosophical part. Getting my point. Okay, right? So always the structure is this is the line and there is a concept. So based on that concept, the conclusion should be this. Did you understood this particular type of question? Yes. Okay. Now let us come to how to approach it. What you can do about it. Okay. Now if you look at it. Very simple approach again. Explain the concept first, right? In order to assess this particular statement, right, we need to first understand about this legal provision, statutory provision, or opinion or any convention, etc. Okay. Then in the body part, handle the philosophical aspect. Here, citing law commission report, good line about it, or the recent judgment in which the judge have remarked the article that I showed you, right? That article will play a very important role there, right? Pick up good lines and write it down. and in the last come up with your view. What do you think? Yes, recently, whether the court have been taking that into account or not, whether the court have been very guarding against this unlimited exercise or discretionary exercise of this right of private defense or not, or in this case that whether recent court judgment have affirmed this concept of social justice or have read this concept of social justice ingrained in the constitution or not, right? There actually you can cite recent case laws also. Here you can cite recent case law in the last paragraph. Okay, recent case law to justify your suggestion. Okay, justify your suggestion. Okay, or conclusion in fact also. And please do not give generic headline, generic subheading, conclusion, body, introduction, not at all. That looks very bad and you will get very less marks for that. Okay, that we will talk about now. Now comes the four type of question that is, I think, the most toughest one, right? That is philosophical question. Just take a beautiful line from any, judgment and write down for the stock or business. Right? So how to handle that? Right? See, a lot of philosophical question actually. The philosophical question is day by day actually increasing, right? The first philosophical question, see, I think it was in 2019 itself. The PIL is not the pills of all ills, right? It is the boon of the court. However, it is also the duty of court to prevent its misuse. So we want to put the best way or method for the appointment of judges in the High Court and the Supreme Court of India. Give your views and support your views. Sustainable development have been accepted as a balancing concept between ecology and development. Right? Can anyone tell me which topic this question relates to? It's a law related to environmental protection. This is a question of CLT. It was asked in 2019 itself. Okay. Similarly, see, the paramount task of the law of tort is to play an important regulatory role in the adjustment of losses and eventuate allocation of their cost until the emergence of a welfare state. Right. So until the state do not take care of citizens, it is the duty of court to take care of the citizens. Right. So until the state do not become a welfare state, the court should assume that role. That is what actually this question is, asking. The law of torts provided the only source for alternative plight of the injured. Right? So the guy is injured. There is no law. Nothing. The state has not made any law. So what is the solution that guy has? So that guy has the solution can be asked only in the law of tort. Right? So tortious remedy is always the solution for it. Right? So in light of our statement, discuss the nature and the scope of the law of tort. Very, very philosophical. So you will have to write the evolution of the law of tort, why actually it came about, right? And how the court have used the law of tort to actually give the justice, right? Actually deliver, give the remedy or the medicine to the people who was actually injured, right? So the Gopal gas tragedy case is a very classical example of it. Or it is generally viewed that what UN did to 20th century for the maintenance of peace and security, WTO is going to play the same role on economic and trade relation of the 21st century, right? So philosophical aspect that how WTO is going to perform, right? Specifically, that the concept of political sovereignty was taken care by the United Nations, but the economic sovereignty will be taken care by the WTO. Very, very philosophical question. Understand that particular point. Okay, right. So these type of questions are very tricky to handle. It can take multiple shapes. I have written also here. It can have multiple approach. It is so fluid that it can take any shape and almost all of them is correct, right? So suppose you write something in building something in it, that doesn't matter. Actually, what actually it wants is a very perfect article. Very perfect article. And let me tell you a secret here. While making your questions, the philosophical question I make like that itself. I have a habit of collecting good article from Hindu, Business Standard, etc., which I keep sending in your group as well, right? So I take that article and I look at the article and I frame the question. Okay, I do it reversely. I do not first frame the question and then frame the answer. I see the article. This is a good article that totally relates to our topic, right? And I frame the question and answer is that article. Obviously, not exactly that article. Some difference would be there, obviously, right? But exactly that is how I frame the philosophical question. Are you getting my point here? Yes. Am I making some sense? No. Yes. Okay. Right. So that is one thing you should keep in mind. Right? That is one thing you should keep in mind. Okay. Now, obviously, if that is something like that, then how to identify that portion? Take like for an example. Let me share you article itself that I, yesterday, in fact, I gave in your, yeah. Can you see this article? Everyone? You can. Okay. If you see this article, can you see this article, everyone? I have shared it. Yes? Yes. Okay. If you see this article is talking about criminal justice system, right? So what I will do is I can frame a question in that criminal justice system have recently shifted from victim centric to criminal centric to victim centric. First off, discuss the lacunae in the criminal justice system with regard to recent events. Yes, don't you think it will be a very perfect question for this particular article? Right? Getting my point? What I'm trying to say. Because in UPSC, you will see these type of courses, philosophy classes. That is why UPSC preparation is very different from judicial. UPSC you will never find this type of question, but in UPSC you will always do. Mostly current affairs based. Clear? Understand that particular point, everyone? Right? So this article I have sent it also, right? In the group, right? I have sent it also, but so try to read those articles. Very important, right? And from that, you should have a habit of taking good point, taking good point. That is a very good thing. Check. Now, let me again share the. Okay. Now, when you see this, what approach you can take, right? So, as I have told you, the approach can be, practically literally anything, right? Here, there is no exact approach or correct approach. It can be literally any approach, right? So, here, what you will do actually is that you will try to explain the concept in which the question is based, right? So, suppose the question number first is based on Article 14 and Article, which is the. So, question number first is based on PI. So, first you will explain the PI, right? In question number 2, right? It is based on appointment of judges. That is the main concept, right? So, we will write that what is the current rate, right? Then, in the second, that is your body part, you will start writing author's opinion, judici's opinion, or any judgment where this particular case or this particular question have been in very dispute. Now, if you don't find it, you have to here make up actually your own word. That is what makes it very difficult, because all other things, there already you must have read something, you will write it. But here you have to actually come up with your own word, right? Obviously, if you have read some good article, you can copy it, obviously, right? But 50% of the question will consist of your own word. But what are the maximum perspective that you can have of that particular? And that is very tough to determine, right? Because you have no clue that what perspective it might have, right? Like for example, suppose there is a question of this. Suppose let us say any question. Let us say this question about question number 5. Suppose. Right, so UN did in 20th. So the first line that you will have to justify paragraph that how UN performed very better vis-a-vis political sovereignty in 20th century. Right. So for UN you have a lot of material, right? Peacekeeping missions, right? They prevented war, they solved multiple disputes, right? So all those information you have to club that in 4 to 5 lines. So that makes it a very difficult thing. Similarly, another thing will be how WTO affects economic sovereignty. So, you have to one line explain also economic sovereignty indicates this. Full stop. WTO is the main governing organization as it governs, mostly the trade-related disputes as well as the trade-related laws between all the nations. Right? So, it means you have to 2-3 lines. You have to actually, sort of compressedly define everything about WTO and economic sovereignty. Right? Understand that particular. Now, that is, that makes it tougher, right? Because as a student of law, you are, right now, hardly you must have studied 2-3 years, right? You might not have that level of sophistication right. I don't know at that level of sophistication right now. Okay, so I also read articles and take out full lines. That makes it very tough. Hope I am making some sense, right? But do not get frightened. You will do it, right? You will do it. Obviously, the moral answer that I will provide, right? In that everything will be very properly, written. Okay, that is what I have written answer. It requires a lot of practice to get it right. So you have to write them multiple. And you will see. But almost nowadays, 30% of the question are philosophical. 30% of the question, especially in constitutional. Constitutional and CND. Getting my point. Okay. So these all 4 type of question is absolutely clear to all of you. No issues at all. Yes. Everyone. Okay. Now, let us proceed to the second part of the today's discussion. That is, how will you write that? Now, that is a very important point. I will show you some copies also. Now, remember that there are 4 important factors to be considered. 3 are the important and 1 is slightly less important, but nevertheless important. That is, your structure of answers should be proper, content of answers should be good, presentation of the answers should be good, and you should adhere to the word limit. Now, plus minus 10% of word limit is okay, but do not go beyond that, right? So if you have a 20 marker question, you have to write 250 words. So if you write 275, 280 words, that's all right. Okay, but do not try to write less. Right? At least try to write, 10% less is okay, but do not try to write less. If you have time, try to write at least 250. Okay. Now, how do you assume it, right? So the best assumption is that always remember that in one line you have around 5 to 6 words, right? So if it is 150 word, that is 10 marker question, you have to write 10 to 12 lines. Just make that in mind. Nothing more, nothing less. That's all. 18 to 29. Okay, 18 to 29, 25. Similarly, 250 words, right? Around 30 to 35 lines. So 250 words, not 30. It is 40 to 45 lines. 200 words, 30 to 35. Understand? Just make a sort of a, do not count there, okay, how much word it is. Just see that, okay, this much line is there, it means okay. You have covered that much part. Understand that part. Clear? Again, quite simple. Again, it is very, very simple. Now, when I say structure, what do you mean by structure? Yesterday, in fact, foundation class also I discussed this, right? If you have seen, you must have seen that. But here I will go in more detail, right? See, I know one of the professors who have checked the copy right now is not checking. He have checked the copy of law, professor of Jamia. He told me that, see, we get a model answer. And in that model answer, we have these headings and subheadings, right? And we are specifically instructed to see that whether each of those headings have been covered or not. It means it gives an idea to the examiner that the demand of the question you have understood and you have fulfilled each and every demand. Okay, so structure plainly and simply speaking means that writing heading and subheadings. Right? Like recently, this article that I just showed you, in which you see the Hindu is the best way to identify the heading and subheading. Right? So they give a main heading, then after each paragraph you will find that there is a small subheadings. Understand? Right now that is something that you need to develop. Okay, I do not write generic headings, right? Body, introduction, conclusion. That sounds very bad. Never do that. Okay, now heading and subheading actually can directly come from question. Like if you see a question, let us take an example. Suppose this is the question. Right? Suppose this is question number first, right? You write about PIL, then the second heading can be social justice in constitution. Achha, it is only PIL. Okay. So is it evil? Okay, that can be one heading. Second heading can be pills for all ills. Okay, third heading can be boon for the citizen. Okay, fourth heading can be its misuse. Right. So simply looking at your question, you can identify that what could be the heading and subheading. Are you getting my point? Simran, Sandhu, Arshi, Aman, Ahmed, Amesh, yes. Dimaag Samajhani, what I'm trying to say. Yes. So just see the question and that from question identify the headings and subheadings. Okay, so that will be a perfect way to approach your answer. Okay? Good. Now, similarly, another thing in the structure can be underlining the diagram. Underlining the major points and making diagram. Right now, making diagram makes sense only we have that direct and direct, right? It overlaps sometimes. Like in the case of murder and culpable homicide, diagram is the best way to identify and explain that concept. Similarly, questions related to international law, where we have, we have to show the boundaries and what are the rights and duties of the state in different boundaries. That is the very best way to show it. Okay. Similarly, if there is a question with regard to suppose, what can we say? With regard to tort, there also the diagram can be used to explain, right? Like some nuisance is punishable or nuisance is not punishable. Okay, so in that you can interplay, you can write down They understand that particular point, right? So mostly in the case of crime and international law, diagram is very important. Okay? But that doesn't mean that, like in geography, geography optional in all of the question diagram is a must. Here it is not there. Hardly you will get 2-3 questions in whole, topic. I mean whole test that you need to make it. Okay? So do not make diagram of everything. Not required. Understand that particular point. Okay? Now, it brings clarity or it helps the examiner to identify it. Right? So that is a very, very important. Now, second thing that I will ask you to keep in mind is the content. Now, content is all about quality. Content is actually, something which you have studied in the classes. Right? Structure is something that you need to develop. Teacher don't teach you that structure. Right? Structure is something that you develop, while writing. But this content is something that actually indicates that how much knowledge you have with regard to that particular topic. Okay, right? So the content is bad. The teacher who taught you is to blame. Right? So some of my students are also giving this, test series, right? So I will suppose that, they will not look badly on me, right? So they should be able to write good content, right? So the qualitative aspect of question is right? It means, do you remember the jurist name? Do you remember, the Latin word involved, right? Do you remember the rationale? Or do you remember good lines about that particular question, right? So it means it's all about that what you exactly have studied in that particular question. Understand that particular point, okay? Right? So it means that is totally, that will, it means structure is something by practice you can get it, but it is something that you once read only, then only you will be able to get it, right? So simply practice will not do it. That is what I am saying, that for each topic you take one whole day and make a program, right? Suppose I will give 2 hours for long. So in 2 hours, one topic, finish it. Tomorrow, one topic, finish it, right? So read as much as you can about that topic. Identify good lines and you write. I mean, you must have done that earlier as well, right? That is very good. Revise it again, right? But if you have not done it, do it. Okay, obviously you have to distribute time among, just for 1, 2, 3, 4 hours, right? But this content part is all about reading. How much you have studied. Okay. Then presentation comes into picture. The presentation actually means everything, right? The answers should look good and pleasing, right? So that the people, when you look at it, right, they would want to check it. The professor would want to check it. They would want to write it down. I mean, read it. Okay. It should not be, very bad. Like, legible handwriting should not be, should be there. It should not be, how much good content you write, how much good structure you have. If the people is not able to read it, you will never get good marks. Okay. Similarly, underlining the important points, that is the part of the structure also. Here also, underline the good points. Right? But underlining do not means do not overdo it. Overdo, underlining each and every portion. Each and every line. That is stupid thing. Okay, do not do it. Only the major things. And do not use multiple pens. One pen is more than sufficient. Okay, because that takes a lot of time. Now, this is a very important aspect that you must remember, that no one likes to read 20 lines written, one by one like this. No one likes to read it. Break it into small parts. And if possible, write a heading in between. If heading is not required, then at least break it. Can you give a space? There are a lot of pages. Page limit is not there, right? They give you almost 2-3 pages for 20 marker, that is to both sides. Almost 60-70 page copy you will get. So page is not in short supply. Okay, we do not have the UPSC where the page are even the pages are in short supply. Right? We have the pages are not in short supply. Right? So don't bother about giving a space. Make it presentable. Make it look good. Okay? Don't have to save tree and write pages, because all of that, the whole paper will get destroyed obviously, right? So you're not saving tree by saving the pages. Okay, so give your proper line. And the last that is your respecting word limit that I've already discussed, plus minus 10%. Now I'm going to show you few answers, and I will ask you to identify that what it is missing. Either it is missing content, or it is missing presentation, or it is missing the structure, Let me show you. Now, this is the first question. This is the question I have taken from foundation batch. Weekly I give some question to write. So from that one question, one of the students have given it. Now see here, the question is that invitation to offer is not an offer. Explain. The typical question, right? When you go to a shopkeeper, you say that okay, I want to purchase this phone, this much rupees. It means you are asking him to make an offer. Right? It is an invitation to offer. sorry, so shopkeeper is asking you to make an offer, right? So it is not directly an offer from the shopkeeper. Okay. Now, what she have started? So she have started an offer and invitation, two distinct terms which must be confused, must not be confused with each other. Okay, very good line. Now see here, see the presentation part. How bad? You cannot write directly, in the beginning itself in the point. You write that in paragraph. Okay. Then see, she have compared something like this. Right. Now, this procedure should be followed. I mean, this special structuring should be followed when you are asked to distinguish between. Right. Okay. So I'm not saying this structure is wrong, but this is a 10-mark question, and this is a lot of things to write. So even if she could have written these meaning or maximum, the consequences, that would have been all right. Okay, that would have been all right. Okay. So when you talk about this method, right? So these are the method when you adopt, or when the question is specifically asked the distinguish between. Then you compare one point to other. Understand? Here they are not asking distinguishing between directly, right? Indirectly of the same question, but directly they are trying to ask you in what manner, in practical sense, that differ. Right? So it means that sort of one. I mean, the examiner want to. I mean, the question the demand of the question is that you should be able to identify with the help of case law what is the difference, right? And what if that interpretation is not followed? What would be the consequences? Okay, so that philosophical type, they're trying to little bit ask about it, right? So I'm not saying that this is the wrong answer, very correct answer, right? But the structure could have been more better. The structure could have been more better, right? Then example of how bad it is. An example of you simply offer versus invitation to offer, give a headline and then write the case and explain it. This giving example is not very relevant. You have written case law, but that is only in one line. No, not at all. You have to use this case law to interpret it, right? To interpret it, and then the philosophical aspect actually you have to write, where the philosophical aspect of any contract law is that the law should follow the commerce, right? Not the other way around, right? So the law should be interpreted in such a way that it facilitates commerce. And that was the purpose of this interpretation. Right? So I've written the comment also, right? Right, what is the rationale behind such interpretation? Law should follow the commerce, rest is good. Understand that particular point. Okay, so if I have to give the number or any comments, so I will write the comment that improves structure. Presentation is okay, probably done everything good, but the structuring is little bit bad. Getting my point. Similarly, let us see another copy. See this copy. Simply by looking at it, what you can say? What it is missing? Anyone? What this question is missing? Yes. Out of that three, what this question is missing? Tell me. No paras, very correct. That is also correct. Very correct. Headlines should have been there. Right, so structure is right. Now, even if the content of this question is actually very good, you have written all the major points and why India did not want to be the part of this treaty. Right? The content is very good, but still he will not get, or he will whoever the candidate is, he will not get very good. Not good, right? This one also seems to be very bad, right? Let's see, very small things actually matter. So should have given a proper right from here. Right? It should look presentable. Content is very good. Structuring, some of the structuring is good as well. They have given very good headings as well, right? Limited scope, but very good heading, right? Feature of the nuclear states, okay. It is in the favor of the nuclear state, that is also correct. Right? But the way it looks do not look nice, right? It means that it should look pleasing. Are you getting what I am trying to say? Content is very correct. Content is very good, no doubt about it. But still, he will fetch less. Understood that particular point? Let me show you third point, third question. See this. This is a candidate again. Now this question was actually law of torts, laws of tort, or it is law of torts. Okay, the question torts and tort. See. So starting with this definition. So should have underlined it, but still, heading here should have written according to Winfield now. See this definition would go in the heading. Definition always go in the heading. Then same written a very generic case law as a subheading. Not good enough. You have to write heading that explains the question and demand of the question, identifies the demand of the question. Not write generic heading. Case laws, conclusion, introduction. That generic heading is not required. Right? So see here, S versus White. The two are very good cases, no doubt. The major difference arises from the fact that the law of tort are different from based on the scope of the what is the C? Again, very bad presentation. Liability which is started in case of torts under flexible interpretation. Are you able to decipher? Okay, right? So the guy who is checking the copy will also not take much pain in deciphering it. They will simply give you, average marks and they will simply go away. Understand that particular point? Okay. So do not write these answers. Some of them is obviously correct, right? Content, structure. There is a lot of copy actually. There is not only one copy. Obviously, they take a lot of copy, right? Like this. This is I think. Good. He's good student actually. He sometimes writes good answers. Like this. Objective is good. With the question. This is the major provision of ITL which has with the help of facilitates online transaction. Okay. Objective written good. Major provisions, electronic governance, e-governance, yes. Direct mail. We have not cited the exact statutory definition, right? Section 4, Section 5 of the ITL, which actually talks about electronic signature, etc. That's what has been cited here. Okay, so that is how I will, give you remark. First two copy, I have told you that I will check 1 to 1. Okay, first not 2 copy, 1 copy. First copy, right? So that you will be able to understand it more clearly. Okay. Now, next thing that this is okay. Everyone understood this 3 things: structure, content, and presentation. Yes. Done. Okay. Now, let's come to the next point of discussion today. Is that which part of syllabus you should focus on? Now, again, let me give a warning first that when I'm saying that these part of syllabus you can focus more, that doesn't mean that the other part you will not focus. Because UPSC is very predictable. It is a brutal exercise to predict UPSC. You cannot predict UPSC. It's better that read each and every topic, but it is just that some topic you give more importance. That's it. Just give half an hour. That's it. Okay. That doesn't mean that you will not read it. Right? So individually, topic by topic, I am going to explain subject by subject. See, in the whole constitutional law, remember this second and third topic and CLD portion of PIL, ADR portion related to legal aid has to be studied together. In CLD portion we have PIL and in CLD portion we have ADR, Alternate Dispute Resolution Mechanism, right? And you will see that the question of legal aid or legal service authority is connected with this. Always. ये समझ में आई बात सबको नोट डाउन कीजिए बहुत इंपॉर्टेंट मैं बातें बता रहा हूँ कि कॉन्स्टिट्यूशनल लॉ में कौन कौन से टॉपिक्स आपको ज्यादा अच्छे से पढ़ना है किससे कनेक्ट करके पढ़ना ठीक है इसमें भी देखिए 2019 में भी एडीआर पे क्वेश्चन आया हुआ था यस आई हैव हियर द आउट ऑफ द क्वेश्चंस राइट if you look at the 2019 paper so you see that there was a question on let me read you the question I will understand much better. See here. Alternate dispute resolution mechanism as provided under the Legal Service Authority Act has played a pivotal role in the dispensation of justice for needy persons, explained with the help of legal provision and case law. Think about it. This is a topic related to Legal Service Authority Act, but it has been asked in Part B of Paper 2, that is your CLD. Getting my point? Yes. बात समझ में आनी चाहिए आपको, ठीक है ना? So that has to be studied in more detail. Okay. Now after that, the second topic that you will find most of question is from legislative and executive relationship. Okay, so topic number 7 has to be given more importance. Okay, and third, always you will find at least 2 questions is from topic number this topic number 8 subpart C. Public Service Commission and especially civil service. Okay, recruitment of services, constitutional safeguard, the civil services under the union state. ठीक है, सो कॉन्स्टिट्यूशनल लॉ में ये 3 टॉपिक पे थोड़ा सा ज्यादा फोकस करना है। लिख लिया सबने? यस, ये अपने कॉपी में नोट डाउन कीजिए, इंपॉर्टेंट है। कॉन्स्टिट्यूशनल लॉ, these 3 topic has to be studied in more detail. Yes. Okay. Now, in administrative law, right, you will find that the most of the question is from these 3: separation of power and constitutional governance. Okay, and they generally connected with the constitutional law. Right, like this year, they have asked, I think in paper 1, there was directly a question, right? What do you mean by constitutional governance or something like that? This year, last year, there was a question. Similarly, what do you mean by constitutional governance? Simple. Because there is a direct type of question. They have simply asked this question. What do you mean by this? Okay, so we'll find a lot of question on that. Understood that particular point? Clear? Now, let us come to international law. In international law, we find that UN is the most important topic. Now, that UN topic indirectly actually relates to peaceful settlement. One of the chapter of the UN Charter is peaceful settlement, and one of the chapter of the UN Charter is the lawful recourse. And UN Charter also deals with fundamental international humanitarian principles. Understood, right? So the UN Charter cannot be studied separately. It has to be studied in relation with these 3 subtopics. Are you getting my point here? Yes. Good. Similarly, second subtopic that you study focus mode is the law of sea. Always 2, 3 questions from law of sea. Always 2 questions from Arabic minimum, right? And the third that you need to remember very nicely is that new international economic order and monetary. Okay, question is always there from this. Okay, so these are the 3 subtopics. In fact, 50% of the syllabus that you will focus on. Always. Okay. Now again, it is based on the previous year, total. But UPSC is known to surprise you. So this was something unique. That is why I am saying that when I am saying that these are the important ones, that means that you have to give extra attention. It doesn't mean that you have to leave everything else. Not required at all. Like for example, this lawful, peaceful settlement of dispute. This you will find, 3 times in this syllabus. That is basically negotiation, arbitration, right? Conciliation, right? So that is there in the Negotiable and Conciliation Act. I mean, Arbitration and Conciliation Act in the portion of your commercial law, right? Laws of contract. Similarly, the same thing you will find in the ADR. In ADR also we have these 3: arbitration, conciliation, and negotiation. Right? So each year you will find at least 2 questions related to ADR here, ADR in this Negotiation and Arbitration Conciliation Act, and ADR that is given in the constitutional law, that is your legal aid. That is also a mechanism of ADR. The establishment of Lok Adalat and permanent Lok Adalat, that is one of the method of ADR, is a subset of, I mean, it has a statutory backing of Legal Service Authority Act also itself. That itself provides that you will have a Lok Adalat or a permanent Lok Adalat. Understand that particular part, right? So this is, it means very, very connected, right? So this question always comes with regard to peaceful settlement. Understand that particular point, right? So even suppose a good line about arbitration. Suppose you need a good line about arbitration. So don't you think that the same line could be used if there is a question of peaceful settlement, if there is a question of normal ADR, if there is a question of arbitration consideration? Don't you think it can be? Yes, it can be. It is overlapping, no doubt about it. Understand that particular point? Okay, good. Now let us proceed to the next, that is the law of crime. In law of crime, the most important one, you must be knowing it, right? Is basically crime against human body. Two questions is definitely there. Now, crime against human body, depending upon the gravity, it increases, right? Assault, hurt, murder. Murder also, murder by someone else, murder by yourself, that is your suicide. Similarly, with regard to offense against human body, some part of it is offense against women, right? Rape, etc. Offense against women, as well as offense against human body, right? So these two has to be studied in very, very specific way. Okay, and second concept that is always needed is basically the crime, which is also referred as sometimes half crime. Right? They are not crime in itself, but when it is done, I mean, when the whole process is not completed, still it is a crime. Right? So half crime, sometimes referred to, right? That are basically constructive liability, abetment, and conspiracy and attempt. Right? So these four can be clubbed together to study. Right? So these are referred as half crime, not a crime in itself until an act has actually come to an existence. Right? These are the concept which, even if the act do not reach its finality, still it is a crime. Okay, right? So that concept is very, very important to understand it. I mean, am I making some sense to you guys? Yes, please tell me. Am I making some sense? Yes or not yes? Yes. Okay. Keep asking so that I should be able to understand it. Okay, so check. Now let us come to the next question. That is your law of thought. And law of thought, I think it is the most easiest paper, right? Why? Why do I say so? Because when you talk about general defense, so there is a specific defense for each thought, and there is a general defense. When you study the general defense, you write, okay, these are the general defenses. And then you also prepare a note and you write that, okay, for a specific thought, there are some specific defenses, right? So club general defenses with specific defenses of all the thoughts. So if there is a question about any particular thought, suppose conspiracy, right? So you write, okay, this is the general defenses which applies to every thought, and this is a defense which is specifically to this particular thought. Right? So this defense is very important. And second is the damage. Second is the damages, that is basically the remedies in the thought. Okay? So defense and damage is very, very important topic in thought. Okay? You will find, invariably when they ask you questions related to these, right? Negligence, defamation, nuisance, right? But either they will ask you, okay, what is the remedy that you have, or what are the damages that you can get. So if you study damages and remedies, right? Then by default, almost you will see that this specific thought is by default semi-completed. Half of it is completed. Understand that particular point. Okay, right? So the damages and remedy, please remember it very important. Right? Sometimes they ask you, right? This year, 2019, there was a very interesting question, right? And when I hired some of students to help me with this preparation of this, right? I mean, formation of the paper, right? So in that I asked them also, and I will ask you as well, that which topic do you think this question relates to? There was a very interesting question in part B of the syllabus. I mean, paper 2 part A, sorry. The ascertainment of the causation is a problem when the event causing damage to plaintiff are not simultaneous but successive. First off, elaborate it with the help of decided cases under the law of thought. Which particular topic do you think this question belongs to? Yes, everyone. I'm opening that question as I will. I will show you. Please tell me that which particular topic that question belongs to. In fact, identifying that which particular topic this question belongs to is an important concept. Let me show you. Yes. Can you see this? Everyone? Yes. Question number 6C. Which do you think it belongs to? Which topic do you think it belongs to? Yes. Tell me. Sorry. Okay. Open. Part A. Yes. This 3C. Which do you think topic it belongs to? Anyone? Law of thought. Yes. I'm waiting. No one? Aman, I expect you to answer it. Contributed to composition areas. Yes. Good. It is mostly contributing areas. Good. Damages in contributing areas. Very good. There's a level to identify. Good. 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 It is contributory specifically. Okay. Right. So sometimes identifying the so this type of Google you will get an exam. Okay. So you need not to worry about these degrees. Okay. I mean it is a part and parcel of the whole process. Okay. It's part and parcel of the whole process. Okay. Now again let us come back to it. Now when you talk about law of contract, now a lot of you what you do actually that you are only concentrated to these 6 questions, 6 topics, only contract. And that is actually wrong. You will find that the 50% of the question is from these. They're not from these. Right? So you only study law of contract, that's over. No, that's you should not do. Right? So what I will ask you that you understand the nature and the formation of the contract and try to connect the same to these 3. I mean these special contracts. Right? These special contracts. Because what are those? Contract of indemnity, guarantee and insurance, it is a type of contract. Right? So the basic nature of agreement or contract will be still there and there will be some specific attribute to these contracts. Right? Like last year there was a question with regard to what are the basic principle of the contract of insurance, right? So like absolute and good faith is a very important principle of contract of insurance. And good faith is obviously a principle of normal contract, but that is not an important principle. Right? That is not an important principle, right? Similarly, contract of agency, right? Now this contract of agency can be connected with basically what? Formation of partnership. The partners are agents of each other. Right? So partnership is nothing, but it is one is a specialized form of agency. It is one of the specialized form of agency. One partner is always agent of another. Right? So what you have to do that you have to study the basic of the contract act and you have to focus more on these specialized form of contract rather than only focusing. People I have seen reading lots and lots about formation, discharge, quasi, and you will get 1% of that. Okay, so this I assume that you must have studied, right? So what you will do that you will focus more on these. Right? Like in the standard form contract, you will find always there is one question, right? And one article that I have written on the website that is more than sufficient for any type of question related to standard form. Nothing more is required. You see the last 20-year paper, and whatever the question comes from a standard form of contract, that article is sufficient to handle. There is a large article that is sufficient to handle. Understand that particular point. Okay, right? So remember it. Now, when you move towards contemporary legal development, that is the people generally leave it. Right? But 2 things I will ask you to read it very interestingly. This particular thing, right? First is the PIL and relate it with the constitutional law, okay, and environmental law. That is your this, right? So PIL has to be studied with regard to environmental law, and it has to be studied with regard to constitutional law. Labor reforms, economic reforms, social reforms, right? Social justice, everything regarded to PIL. Okay, because here they can ask PIL with regard to anything, but most of the time they ask PIL question with regard to environmental. If you look at the 2019 or 18 paper, I could see some of the question which was directly with regard to PIL with regard to environmental. Understand that particular point, okay? Or very simply, it is like this question that I discussed earlier as well. PIL is not pill of all else, it is boon of the court. However, it is also the duty of the court to prevent its misuse. Right? Similarly, 2018, you will see a question about PIL, and how PIL have helped to frame the environmental policy in India. Okay, so PIL has to be studied with respect to environmental law and other aspects. But mostly, if you will cover environmental law, that will be more than sufficient. Like see, public interest litigation of late have been used not only to represent the unrepresented and weak, but also to advance the interest of others. Full stop. Comment on the recent trend relating to the application and use and misuse of PIL. Right? So use you can write multiple things. Misuse also you can write multiple cases. So the misuse actually you have to write all the cases where the court have dismissed it. Okay, right? You must have heard about a lawyer Sarma. Have you heard about a lawyer Sarma? Yes, ML Sarma. Have you heard about that lawyer ML Sarma? No? Yes. So you will see that lawyer ML Sarma, he always files a PIL, right? And that PIL is always, you will see that PIL is always it is, it is dismissed, right? Most of the time actually it is dismissed. Right? So that can be cited in that. Second thing that I will ask you, ADR already covered along with that, right? Second thing that I will ask you, that you try to study this right to information. Definitely one question is there. And they very cleverly arrange the question, right? I mean, they give you, like suppose, you have question number 6, 6A, 6B, 6C. Suppose 6A, 6B, 6C, right? So they purposefully, they will give 6C as a question of CLD. So if you do not have studied CLD, even if you can solve A and B, you cannot solve C. Right? So they have very cleverly arranged it. Right? You cannot skip CLD at all. Understand that particular point. Now in CLD portion, if you need any help, obviously you can tell me and I will help you and write that figure. And it is not very large, right? The whole CLD I teach in 15 days. More than that is not required. It is not required at all, right? And the best thing that I will tell you, the question that I will prepare in the CLD, their solution will be such that it will be a note in itself. Right? So that is the one thing that I will request you, that you have to take the solution, right, and keep it with you. You will find that at least 50 to 60% question is verbatim, and that is not a surprise. I am not, trying to be hero that okay, I am getting question is coming in exam. No, it is repeated question, right? Even you will set the question, that will come in exam. Okay, the main point is the model answer. Right? The main point is actually the model answer. So you keep the model answer, use the model answer as a notes as well, right? So just before the exam, model answer can be used as a quick revision. Getting my point here? Understood? Okay? Yes. So to sum up, we have discussed 3 things, 4 things actually. First thing that we have discussed is, routine of the test, how to better utilize it, what will be the structure. Second thing, we have discussed the type of question asked and approaches. Third thing, writing, what things to keep in mind and part of the syllabus that should be focused. Okay. So these are the only 4 things that is required in the strategy of the law of the series, right? And more than that, nothing is required. So if you can, adhere to these 3, these 4, more than sufficient. In fact, more than sufficient. Understand that particular point. Yes, everyone. Okay. Now I will take any question that you might have. And there is an option of raising hand, right? So you can raise your hand, and I will simply unlock you. Okay, and you can ask a question. Yes, go ahead. If anyone have any question. Yes. First test you will get in the morning of the 16th. Okay. So we'll have to write that and start reading from today itself. We have 1 week. All of you have got the test syllabus or not? All of you have got the test syllabus? Yes. It is on the website itself. You can see from there. Yes. Aman. Yes, Aman. Go ahead.
Yes, sir. So, in the beginning of the session, you discussed that you will be sharing the recent case judgment synopsis with us. So, I was asking when will it be so that we can use them in our answers that we will be taking the tests.
Type it also. You can type here. I can answer that. You can type it. Anyone have So out of 15, 17 guys who were withdrawn, only 7, 8 of you cracked up. Everyone else joined themselves. No, one of them actually, Gauri, I think, Gauri Sukla, she emailed me, said I will be not able to attend. Just he was asking one particular case as well. That repromulgation of ordinance, right? She asked me that, sir, you please tell me that which particular case is, right? So I will send her the article as well, but for you also, right? There are multiple grounds on which in our branch can be challenged, right? In one of the lectures of which we have discussed it. His name is Krishna Kumar Singh versus State of Bihar. I told only State of Bihar, something versus State of Bihar, I could not remember. And DC Vadava also. That is also a case related to this repromulgation of ordinance. Okay, yes. I don't think there's any question. Aman, you are muted, but still we cannot hear you. Your sound, internet might not be working.
Hello.
You can type also. You can ask me, email me. Let me give you my email. Obviously, everyone have my email. I mean, if you do not have, take my email. Any question, you personally email me. Individually, I will reply. Right? And if required, we can have this one-to-one discussion. Okay. Aditya Tiwari, Tiwari. Okay. At the rate outlook.com. Okay, Tiwari at the rate outlook.com. Right, so email me if any question that you might have. Done? Yes, everyone, done? So, wind up kare fir aaj ke liye. Let us wind it up now. Okay? Aman, still I cannot hear you. I think your sound is there's a problem with regard to your sound. First aid test. One by one I am answering. One is asking, sir, what will be the format of the first aid test? It will be very simple, right? The 4 questions from part A, 4 questions from part B. Okay? I mean, the syllabus, suppose there are 8 topics in the syllabus, right? So 8 topics will have total 8 questions, right? And all of you must be knowing that question number 1 and 5 will consist 10 questions of 5 mark each, and the rest of the question will consist of 3 questions. You have to solve any 5 of them. Exact UPSC. Exact UPSC. Okay. Simran, your question, your answer is solved. The question is solved. One is asking that just inquiring when we will be receiving the synopsis of the literature. That I will give you in the last. I have told you that I will give you. I will also prepare it, right? So the next 1 month or so, I will prepare it. Right? And once you are done with the, I want that particular synopsis to be to be acted as a last tool before you go into the exam. Okay, that I will give you in the last, not in the beginning. Okay, so that I am telling you guys now. It can be a little sooner, but I have this crash course also coming up. This time a lot of students are there, so I think there will be 2 batches of dogs, right? So 6-hour class I have to take daily, right? And you will be also writing answers. I will evaluate it as well. Right? I have some help. I have 2 guys helping me, 2 girls actually helping me, right? But still, I will try. I will try to do it. Okay? I will try to do it. Yes. Can you send us the document that you were showing us? Yes, that document we will send you. Jisan will send you. He will send you. Not to. Personally, I will also send you. They have given me all your number and email ID, and I will send you. Okay? Then, Arusi, you have any question? Animesh? No? No question. Okay. Find it up, and you have an email ID. Any question you personally mail. When I start, do not waste time. And that is a very important thing. Please do not waste time. Each and every second is very critical. Let me remind you. See, yesterday, day before yesterday, that girl, who was a test student last year, she was telling a very critical thing. I asked her that, a lot of people will not qualify for it. So she gave a very interesting answer from the student perspective. That, see, sir, what you should do, that you should prepare for mains in such a manner that the year that you qualify prelims, you should be able to qualify. That was a brilliant answer you asked. The prelims is so dicey that it is an opportunity if you clear the prelims, right? Because next year, whether you will be able to clear prelims or not, you cannot predict, right? So once you clear prelims, and most of you must be clearing it this time, right? So that should be the only time that you require to clear prelims, right? You should be able to qualify it. Okay, so please keep that in mind. Because the prelims question you must have seen are becoming dicier and dicier. Right? There are students who are very brilliant. They get, I sometimes give them 160 mark in one paper. Right? So if they write actual mains, they will get, they will be in topper. But they are not qualifying prelims for last 3-4 years. Right? So this is really a golden opportunity that you guys are qualifying prelims. Okay? So please do not waste it, because next time you might not get that opportunity. Let me be very frank with you. Getting my point, everyone? Okay? And do not let this word discourage you, right? But that is exactly the point. And that is exactly what is happening these days. Okay, everyone? Yes? So I will not again waste more time. Good luck. 16th, you will get the question paper in the morning itself, right? Or in the 15th evening itself. You write it in whole 1 week, and you try to submit it by, Wednesday or Thursday, so that I can arrange in the weekend, 1-to-1 in class. Okay? Then everyone? Check. So that will be all for today. Thank you.